Hello everyone. My discussion will be all about loan, deposit, um, commodatum, mutuum, antichresis, and pledge. So we start with loan. So a contract of loan, under Article 1933 of the New Civil Code provides that, one of the parties delivers to another either something not consumable so that the latter may use the same for a certain time and return it, in which the contract is called a commodatum. It can also be a money or other consumable thing upon the condition that the same amount of the same kind and quality shall be paid, in which case the contract is simply called loan or mutuum. So, in a contract of loan, can be either a commodatum or a mutuum. A mutuum is otherwise known as the loan. So if the thing is a consumable thing, it is a mutuum. If it's not consumable, it is a commodatum. So how are you going to distinguish whether it is a commodatum or mutuum? For mutuum, the debtor shall return to the creditor an equivalent amount of the subject matter. While in a commodatum, the same thing that was delivered should be returned. So this means that, for example, the thing loaned or thing borrowed is a cabinet. Since a cabinet is not a consumable thing, that is considered a commodatum. An example of consumable thing is, for example, let's say money. Money is a consumable thing. So that is a mutuum. Another difference between commodatum and from mutuum is that in a mutuum, it may be gratuitous or onerous. Gratuitous meaning it is free or without payment, while an onerous one is with payment or may kapalit, or with consideration. In a commodatum, it is essentially gratuitous. So those that are not consumable thing, it is essentially gratuitous. Another one is that the borrower in mutuum acquires ownership, while in a commodatum he does not acquire ownership. The reason is that in a commodatum, being not consumable, the borrower shall return the same kind, or the same property shall be returned to the party to whom he borrowed from. Mutuum refers to personal property, and commodatum refers to real and personal property. An example of real property is building. Another is land. For example, what is borrowed? What is borrowed is the land covered by a torrent's title. Titulo ng lupa. If the thing being pledged or being borrowed is the document itself, yung torrent's title mismo, and not the land, then it can be considered a personal property. However, essentially, that is a real property. Kasi nga, yung lupa is covered in a title, and the title is a proof of ownership, although not absolute. So in this situation, if there is a lack of written stipulation to pay the interest on the loan amount, paano pala ang mangyayari kung may kulang or may lack doon sa stipulation or doon sa kontrata na kailangang magbayad ng interest. Okay? Ang sabi ng batas, it is well settled, okay, that if there is no express stipulation on the interest, no interest shall be due. Ang ibig sabihin lang yan, kung walang kasulatan na nagsasabi na may interest yung utang. For example, 100,000, 1% na 100,000 ang pinapag-usapan. Kung walang dokumento na nagpapakita or nagpo-prove na meron ngang interest na napag-usapan between the creditor and the debtor, sabi ng batas, no interest shall be due. Also, if the parties did not put down in writing their agreement, the interest shall not be due. The collection of interest without any stipulation in writing is prohibited under the law. Okay? Another one is 2.5 interest per month consumable or not. Ang sabi ng batas, it is not consumable. Okay? The willingness of the parties to enter into relation involving an unconscionable interest rate is inconsequential to the validity of the stipulated rate. Okay? This is considered by the courts as contrary to morals and the law. Okay? The same ruling was made in the case of Marilag versus Martinez. Ang sabi ng batas doon, where a contract of loan secured by mortgage was entered into with a stipulated interest of 3% per month, that is unconscionable. Ano bang unconscionable, ma'am? Ito yung mga shocking to the public. Okay? Siyempre, uutang ka na nga lang, tapos ang laki-laki yung pa ng interest, that is shocking to the public. Okay? Let's go to commodatum. Okay? Again, ang sabi ng batas, okay, object of mutuum is consumable, where a contract of commodatum may have as its object consumable things. In the case of producer bank versus Court of Appeals, okay, as a rule, if the subject of the contract is consumable, it would be mutuum. Diba? Kung consumable yan, mutuum daw yan. Pero, okay, however, there are circumstances where commodatum may have its object a consumable thing. Okay? Under the law, consumable goods may be the subject of commodatum if, tandaan nyo to, if the purpose of the contract is not the consumption of the object, as when it is merely for exhibition. That is provided under Article 1936. So, ang ibig sabihin lang nito, okay, if the consumable goods are loaned or borrowed for exhibition only, or when the intention, kung ang intention ng mga parties is to lend the consumable goods and to have the very same goods returned at the end of the period agreed upon, the loan is considered to be commodatum and not mutuum. Okay? So, there are also some circumstances when the bailee is liable even in cases of fortuitous event. Okay? Diba? Ang sabi natin sa batas, pag there is a fortuitous if the thing is lost or destroyed because of fortuitous event, the party shall not be liable. Okay? However, in these circumstances, the bailee is still liable for the loss of the thing even if it should be through the fault of a fortuitous event. Number 1, if he devotes the thing to any purpose different from that for which it was loaned. For example, if the thing loan is only for exhibition or for display purposes, okay? Pero hindi niya ito ginamit for exhibition at hindi niya ito ginamit for display purposes. Ang ginawa niya is tinambak niya sa loob ng bahay niya, tapos yung bahay niya nasunog. Okay, the bailee shall be liable. Another one, if he keeps it longer then the period stipulated or after the accomplishment of the use for which the commodatum has been constituted. In this one, kung mapapansin ninyo, there is a violation as to the terms of the contract pertaining to the period itself. So if the party kept the thing outside, outside or longer than the stipulated period, then and the thing was lost after, the stipulated period, then he shall be liable. Anything that happens to the thing after the stipulated period, he shall be liable. Another one, if the thing loaned is delivered with appraisal of its value unless there is a stipulation exempting the bailee from responsibility in case of fortuitous event. Next one, if he lends or leases the thing to the third person who is not a member of his household. So pag pinagamit daw niya yung bagay na yon sa ibang tao, or the third person. In this one, he shall be liable. Bakit naman? Kasi nga in a contract, the contract is considered to be sacred between the parties whose names appear on the contract. So, kung sino ang andun sa laman ng kontrata, sila lang dapat ang gagamit or dapat i-abide nila ng maayos at mabuti yung nakalagay sa kontrata. Hindi pwedeng ipagamit na lang ng basta-basta. If another one, if being able to save either the thing borrowed or his own thing, he chooses to save the latter. So, for example, there is a fire and there are items na nasusunog na and he chooses to save his own property rather than the thing he borrowed. That is equivalent to liability under the commodatum. Let's go with deposit. In a deposit, what is a contract of deposit pala? A contract of deposit, is constituted from the moment a person receives a thing belonging to another with the obligation of safely keeping it and returning the same. What is the nature of contract of deposit? A contract of deposit is essentially gratuitous. There are, however, exceptions to the following, as when there's agreement to the contrary or when the depositary is engaged in the business of storing goods. An example of this one is pag pumupunta kayo sa grocery and you deposit your belongings to the yung person, yung baggage counter, diba, kung maalala ninyo sa mga area ng grocery. In that one, you don't have to pay any amount in order for the baggage counter to keep your belongings. So that is essentially gratuitous. An example of or as an exemption thereto is pag engage yung business in storing goods. Example of this one is yung mga bank. Di ba yung mga bangko may fees yung pag magde-deposit ka ng pera, meron tayong tinatawag na minimum na amount not to spend it in order for your account para hindi mag-close. Since yung money na yan is nagkakaroon ng increase, I forget the term, but yung pera nyo na nakadeposit sa bangko, nagkakaroon ng interest yan. And at the end of every year, meron tayong babayarang mga fees, para as a fee for storage of storing the goods. And another one is yung mga situation kung saan pinapatago nila yung mga documents nila na importante sa mga businesses. Yan. So what is the nature of rent of safety deposit box. To yon. Okay? It is a special kind of deposit. Okay? Since the primary function is still the safekeeping of funds, documents, and other objects. The renting out of the safety deposit box is not independent from but related to, in conjunction with the function of safekeeping. Can the depositary use the thing being deposited? As a rule, okay, the depositary may not use the thing deposited, except, okay, the following circumstances. Number one, if the depositor, okay, you expressly permitted the depositary. Pag pumayag kang gamitin yung yung dineposit mong bagay. Another one, when the preservation of the thing deposit requires its use. Okay? So, in this one, kung mas masisira yung item pag hindi ginagamit. Okay? And usage is necessary in order for it to preserve the item, then the depositary may use the thing deposited. Of course, the use should only be for the purpose intended. Okay? So, if the depositary uses it in the ordinary course of business, okay, the contract may no longer be a contract of deposit, but it may be a different one like loan. Okay? The exemption is if the safekeeping is still the principal purpose of the contract. So, even if the depositary can use it, it is still a contract of deposit. Another one, when the depositary is liable in case of loss of the thing deposited, even in case of fortuitous event. So, in your Article 1979, you can find the requirements. Number one, if it is so stipulated. Number two, if he uses a thing without the depositor's permission. Number three, if he delays its return. And lastly, if he allows others to use it, even though he himself may have been authorized to use the same. Okay? Always remember that the business of banks are imbued with public interest. So, if there is an unauthorized withdrawal from the account of the depositor, okay, the bank shall be liable because the bank did not exercise the degree of diligence it is ought to have exercised in dealing with its client. And the diligence required to the banks is that the diligence higher than that of a good father of a family. So, next is the necessary deposit. Ano nga ba itong mga sinasabi nating necessary deposit? An example is the liability of hotel keeper if a car is lost at the parking area. If you go to, for example, Hotel Roma, dun sa area where designated parking area. If you park your car within the designated parking area of the hotel and your car was lost, okay? Nakarnap yung sasakyan nyo, the hotel will be liable. This is covered under the necessary deposit, okay? Can the hotel keeper be excused from liability for the loss of the things belonging to its guest? Okay? In your Article 2002, it provides that the hotel keeper is not liable when the thing is lost due to the acts of the guest, the family, servant, or the visitor, or when it arises from the character of the thing brought into the hotel. So, if your car was taken secretly by your own wife or your own husband, and it was proven that it was due to them, then the hotel will not be liable. However, the hotel keeper cannot free himself from responsibility by posting notices at the hotel because the law says that the hotel keeper cannot free himself from responsibility by posting notices to the effect that he is not liable for the articles brought by the guest. This is provided under 203, the said stipulation is considered to be void. Kung mapapansin ninyo sa mga hotels, may mga nakapost, ang nakasulat is, hindi daw sila liable just in case their personal belongings are lost. That post or that notice considered by law as void, okay? And that is prohibited under Article 2003. How about if there is a negligence on the part of the hotel keeper? Okay? Paano kung may kakulangan or may pagkukulang ang hotel keeper? Ang sabi ng batas, okay? If the employees of the hotel assisted a person in opening the safety deposit box of the guest, as there was a key in her possession, which she admitted as having stolen the same while the guest was asleep, the hotel keeper is liable because the management had been remiss in complying with the obligations imposed upon hotel keepers under the law. The employees knew, okay, that another person had access to the safety deposit box, but they never informed the guest at all. It is a mark of negligence, sabi ng batas. So, under Article 1170 of the New Civil Code, those who in the performance of their obligation are guilty of negligence are liable for damages. So, as to who shall bear the burden of paying the damages? Article 2180, paragraph 4 of the same code provides that the owners and the managers of the establishment or enterprise are responsible, okay, for the damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of the function. So, if the employee committed a mistake or a negligence, the managers and the owner of the building or the business shall likewise be liable. It is also settled by the court, okay, that if an employee is found negligent, it is presumed, okay, that the employer was also negligent in selecting or supervising him, for it is hard for the victim to prove negligence of such employer. Okay? What is the effect naman? Okay? What is the effect in case of valet parking? Ano tong valet parking? Pansin ninyo kung dun sa mga napapanood natin sa TV na magpapark ng sasakyan nila, tapos iiwan na lang nila yung susi doon sa taong nasa harapan ng hotel. Okay? And they are called to be the valet. Okay? In this one, so, in the case of Durban versus Pioneer, if a car was lost in a valet parking, the depositary is still liable because there was a contract of deposit with the hotel keeper. The contract of deposit was perfected from the owner's delivery when he handed over the keys to his vehicle with the parking attendant with the obligation of safely keeping and returning it. Hence, it is liable for the damages for the loss of the car. Question: is it necessary that the thing owned by the guest be submitted or surrendered to the hotel keepers to be liable? The answer there is answered in the case of De Los Santos versus Tanki. The court said that to hold hotel keepers or innkeepers liable for the effects of their guests, it is not necessary that they be actually delivered to the innkeepers or their employees. It is enough, okay, ang sabi ng batas, it is enough that such effects are within the hotel or inn. So, ang sabi ng batas, hindi po kailangan na isurrender o isubmit lahat ng mga bagay na meron tayo or dala-dala natin doon sa hotel keepers. Ang sabi ng batas, as long as those items are within the hotel or inn. Okay? With greater reason should the liability of the hotel keeper be enforced when the missing items are taken without the guest's knowledge and consent from a safety deposit box provided the hotel itself, as in the case of YHT Realty Corporation versus Court of Appeals. So, next. How about antichresis? I will just give a very short discussion about antichresis later. So the theory, an antichresis, okay, by the contract of antichresis, the creditor acquires the right to receive the fruits of an immovable of his debtor with the obligation to apply them to the payment of the interest if owing, and thereafter the principal of his credit. This is provided in your Article 2132. The amount of the principal and of the interest shall be specified in writing. Otherwise, the contract of antichresis shall be void. Okay. Always remember in a contract of antichresis, okay, it is the creditor who acquires the right to receive the fruit. Okay, in an immovable of his debtor. Remember, in antichresis, the object involved is an immovable or a real property. Again, a real property or immovable property example is building, bridges, land. Okay, those that are incapable of moving from one area to another area is an immovable property. Okay, kahit isang bahay kubo pa yan, okay, and it's capable of bayanihan, movable through bayanihan, it is still considered to be immovable. Even those that are floating houses, that is considered to be immovable. So, okay, pledge and mortgage. Okay, I will discuss that later. Punta tayo sa let's go now to pledge and mortgage pala. Sorry. So what are the requisites of the contracts of pledge and mortgage? Okay, number 1, that they be constituted to secure the fulfillment of a principal obligation, that the pledger or mortgagor be the absolute owner of the thing pledge or mortgage, that the persons constituting the pledge or mortgage have the free disposal of the property, and in the absence thereof, that they be legally authorized for the purpose. That the thing pledge be placed in the possession of the creditor or of a third person by common agreement, that a description of the thing pledge and the date of the pledge appear in a public instrument, and lastly, that the document in which it appears be recorded in the registry of property. The concept of equity in redemption or equity of redemption. It is the right of the mortgagor to redeem the mortgage property after his default in the performance of the conditions of the mortgage, but before the sale of the mortgage property or confirmation of the sale. So, what is the concept of right of redemption? Yung kanina is equity redemption. Ano naman ang right of redemption? It is the right of the mortgagor to redeem the mortgage property within a certain period after it was sold for the satisfaction of the mortgage. It is supposed to be exercised within 1 year from registration of the sale. So, ang right of redemption has an expiration. Always remember that. Usually, it's 1 year from the registration of the sale. How about equity of redemption? Ang equity of redemption is it is also a right, okay, but it is the right to redeem the mortgage property after his default in the performance of the conditions of the mortgage, but before the sale of the mortgage property or confirmation of the sale, while the right is after the registration of the sale. So, what is a pactum commissorium? A pactum commissorium, okay, in a pactum commissorium, if a contract of pledge is with the condition that if the debtor cannot pay his obligation, the creditor shall become the owner of the thing pledge. This is considered to be void because this is considered a pactum commissorium. Sige, simplan natin. For example, ikaw ay umutang sa kapitbahay nyo. Okay? That is ang usapan ninyo is pag hindi ka nakabayad ng 500,000 yung utang mo, yung kapitbahay nyo, siya nang may-ari ng bahay ninyo. Is that allowed by law? Kaya ang sabi ng batas, that is pactum commissorium. So, that is not allowed. Under the law, the creditor, yung kapitbahay ninyo, he cannot appropriate the things given by way of pledge or mortgage or dispose any of them. Any stipulation to the contrary is considered as void under Article 2088. This stipulation is contrary to the nature of a true pacto de retro sale. Why? Okay? Since in such sale, the ownership of the property sold is immediately transferred to the vendee a retro upon execution of the sale, subject only to the repurchase of a vendor a retro within the stipulated period. We will further discuss this in sale. Okay? Don't worry. So, undoubtedly, the aforementioned stipulation is a pactum commissorium because it is enabled the mortgagee to acquire the ownership of the mortgage property without need to foreclose the proceeding, which is absolutely in nullity, being contrary to the provisions of Article 2088. Okay, always remember na pag umutang ka sa kapitbahay nyo ng 500,000 or any amount thereto, and you pledge your house as a security to the said loan, that is considered a pactum commissorium if you failed to pay your debt and the creditor or yung kapitbahay automatically acquires ownership thereto. Bakit hindi to allowed ng batas? Because accordingly, sabi ng batas, you should have or you are given the right of redemption. Okay? You have still the right to redeem your property in that case. Okay? And that is void, of course. And of course, the creditor cannot just appropriate the thing given by way of pledge or mortgage or dispose those property. Okay, always remember that such stipulation is void. What is the reason for prohibition against pactum commissorium? Always remember that the prohibition against pactum commissorium is intended to protect the debtor, the pledger, or the mortgagor against being overreached by the creditor who holds the pieces of the property, the value of which is more than valuable than the amount of debt. Okay? So, pinoprotektahan ng batas yung mga taong umuutang. And ang sabi ng batas, dapat protektahan to kasi alam naman natin na yung property being pledged is far more valuable than the amount of the debt. Okay? So, what is the remedy of the creditor in order that his credit may be satisfied? So, ano daw ang remedyo? Para yung creditor naman, hindi naman bias on his part. Paano naman maging masatisfy? Of course, the thing pledge or mortgage must be alienated to satisfy the payment of the obligation. So, mag-undergo ng alienation of the property, yung property being pledged. Okay? So, it can be sold or pwedeng i-auction, mga ganun. So, the creditor cannot appropriate the object of the mortgage or pledge, okay? What he can do so, okay? He can do so if after the conduct of public auction, kailangan po ng public auction, okay? Tapos walang bidder, and another public auction should be conducted. If still there is no bidder, he cannot appropriate the object of the pledge or mortgage that is provided in your 2112. So, what is the remedy of mortgagee in case the mortgagor defaults? The rule is now settled, okay? That a mortgage creditor may elect to waive his security and bring instead an ordinary action to recover the indebtedness of the right with the right to execute a judgment thereon. And all the properties of the debtor, including the subject matter of the mortgage, subject to the qualification that if he fails in the remedy elected by him, he cannot further pursue the other remedies which he waived. Can the mortgagor sell the property mortgage without the consent of the mortgagee? this is the application of directo law in your Article 1484. Okay? The mortgagor may sell the thing mortgaged, but always remember, when the mortgagor sells the mortgaged property to a third person, the creditor may demand from such third person the payment of the principal obligation. So the reason for this is that the mortgage credit is a real right which follows the property wherever it goes. So even if its ownership changes. Okay, remember also that in your Article 2129 of the Civil Code, it gives the mortgagee the option. Sino ba itong sinasabi kong mortgagee? Ito yung nagpautang. Okay? It gives the mortgagee the option of collecting from the third person in possession of the mortgage property in the concept of owner. So, the mortgagor owners, ito yung umutang, okay? So, the mortgagor owner's sale of the property does not affect the right of the registered mortgagee to foreclose on the same, even if the ownership had been transferred to another person. The latter is bound by the registered mortgage on the title he acquired. What is this so-called Dragnet clause or the blanket mortgage clause? A blanket mortgage clause, also known as the Dragnet clause, is one which is specifically phrased to subsume all debts of past or future origins. So in this one, okay, the mortgages of this character enable the parties to provide continuous dealing. Okay, the nature or extent of which may not be known or anticipated at the time, and they avoid the expense and inconvenience of executing a new security on each new transaction. So this Dragnet clause, okay, ito yung nag-ooperate as a convenience and accommodation to the borrowers, as it makes available additional funds without them having to execute additional security documents. Okay? So, is this valid? Ang sabi ng batas, it has been settled in a long line of decisions that mortgages given to secure future advancements are considered to be valid and legal contracts. And the amount named as consideration in said contracts do not limit the amount for which the mortgage may stand as security if from the four corners of the instrument they intend to secure future and other indebtedness can be gathered. So that ends the discussion for credit transaction. We only selected important topics. Later on, I will also give the discussion on cases or regarding case analysis. Thank you for listening and have a nice day.